Before we begin, a quick and important disclaimer. This video is provided strictly for educational and entertainment purposes and does not constitute legal, career, or financial advice. The statistics, historical trends, and case studies discussed are based on aggregated data and should not be used as a definitive guide for individual legal strategies or professional career moves. Law and its economic implications vary drastically by state and jurisdiction. You are strongly encouraged to conduct your own due diligence and consult with qualified legal and financial professionals regarding your specific situation. In the United States, there is a singular profession that thrives precisely when the most fundamental unit of society, the family, begins to fracture. While many view the divorce lawyer as a necessary evil or a high-priced gladiator in the arena of heartbreak, the statistical reality of this occupation reveals a much more complex economic machine. Every year, approximately 600,000 to 700,000 divorces are finalized across the country. Behind these filings is a workforce that manages a cumulative $13 billion in annual revenue. But here is the shocking reality that most people miss. While the national divorce rate has actually declined over the last 2 decades, the cost of the average divorce has skyrocketed, and the barriers to entry for this profession have become more grueling than ever. We are entering an era where there is a massive disconnect between the number of people needing legal help and the number of professionals capable of providing it at a price the middle class can afford. This creates a high-stakes environment where a single billable hour can cost more than a family's weekly grocery budget, yet many practitioners are facing burnout rates that rival ER doctors. This deep dive masterclass is designed to solve a critical problem for our audience today: the lack of transparency in the legal industrial complex. Whether you are a law student considering a specialization, a professional looking to understand market trends, or someone trying to navigate the financial logic of the legal system, this analysis will strip away the emotional rhetoric. We are going to look at the hard data regarding income percentiles, the true cost of the billable hour, the impact of the gray divorce trend on lawyer profitability, and the statistical likelihood of success for boutique firms versus large-scale practices. By the end of this 10-part series, you will understand the divorce lawyer occupation not as a collection of tropes from television dramas, but as a calculated, data-driven sector of the American economy. To understand where the profession stands today, we must first look at the historical trends that have shaped the current labor market. In the 1970s, the introduction of no-fault divorce laws across various states fundamentally changed the product that divorce lawyers sell. Previously, a lawyer's primary job was to prove fault: adultery, abandonment, or cruelty. This was a labor-intensive investigative process. When the legal standard shifted to irreconcilable differences, the focus of the occupation moved from private investigation to complex asset division and child custody mathematics. This shift created a demand for a different type of professional: the forensic accountant-lawyer hybrid. Today, the Bureau of Labor Statistics does not always separate family law from the broader category of lawyers, but industry-specific data suggests that family law practitioners make up roughly 10 to 15% of the private practice workforce. The entry-level reality for this occupation is often a shock to the system. Potential outcomes for a new family law associate in a metropolitan area like New York City or Los Angeles typically involve a starting salary ranging from $75,000 to $115,000. But this comes at a high price. The billable hour requirement is the primary metric of success. Historical trends show that a standard associate is expected to bill between 1,800 and 2,200 hours per year. To achieve 2,000 billable hours, a professional often has to spend 2,500 to 3,000 hours in the office, accounting for administrative tasks, networking, and the non-billable time spent on continuing legal education. When you break this down statistically, the hourly wage for a high-performing associate can actually be lower than that of a specialized tradesperson when the total hours worked are factored against the net take-home pay after student loan debt is serviced. Speaking of debt, the educational path to becoming a divorce lawyer is a significant part of the statistical analysis. The average law school graduate in the United States leaves campus with approximately $145,000 in debt. For those specializing in family law, the return on investment can be slower than for those in corporate or intellectual property law. However, the family law sector is famously recession-proof. Case studies from the 2008 financial crisis and the 2020 global lockdowns show that while corporate mergers and acquisitions may stall during economic downturns, domestic litigation often increases or stays steady. Economic stress is a primary driver of marital friction, meaning the demand for divorce lawyers often has an inverse relationship with the health of the overall economy. This makes the occupation one of the most stable, albeit emotionally taxing, paths in the legal field. Let us look at the demographics of the profession. Over the last decade, there has been a significant shift in the gender composition of family law. Historically a male-dominated field, recent data suggests that women now make up more than 50% of new family law practitioners. This demographic shift is influencing how firms market themselves and how mediation is prioritized over litigation. Statistically, cases that go to full trial represent less than 5 to 10% of all divorce filings. The vast majority are settled through negotiation and mediation. This means the modern divorce lawyer must be more of a diplomat and a strategist than a courtroom brawler. The skill set required has evolved from aggressive oratory to high-level financial negotiation and psychological management. One of the most profitable emerging sectors within this occupation is what sociologists call the gray divorce. This refers to the doubling of the divorce rate for couples over the age of 50 since the 1990s. From a lawyer's perspective, these cases are statistically more lucrative. Younger couples often have more debt than assets, student loans, upside-down mortgages, and car payments. Older couples, however, have 401ks, pension plans, real estate equity, and business interests. The complexity of dividing these assets requires more billable hours and higher expertise in tax law. A case study of a typical gray divorce in a high net worth bracket might involve 6 months of discovery just to value a single privately held business. This is where the top 5% of earners in the field operate, often commanding hourly rates that exceed $700. However, we must also address the darker side of these statistics: the burnout rate. Family law practitioners consistently rank near the top of the legal profession for career dissatisfaction and mental health challenges. The secondary traumatic stress of dealing with child custody disputes and domestic violence takes a measurable toll. Historical trends indicate that many lawyers leave family law within the first 5 to 7 years of practice, either moving into mediation, estate planning, or leaving the law entirely. This high turnover rate creates a constant vacuum of mid-level talent, which in turn drives up the cost for consumers because the remaining experienced lawyers can charge a premium for their expertise. As we move through this analysis, we will see that the divorce lawyer is not just an individual, but a cog in a much larger economic system. From the filing fees that fund the court system to the expert witnesses, psychologists, appraisers, and accountants, who derive their income from these cases, the occupation supports a massive secondary economy. We are going to examine the geographical variations in earnings, where a divorce lawyer in Miami might see a totally different profit margin compared to one in rural Ohio, despite having the same degree. This is a masterclass in the business of the end of love, and we are just getting started with the data. To understand the geographic arbitrage of the divorce lawyer occupation, let us examine the life of a practitioner named Mark in 2026. Mark operates in Miami, Florida, a city where the cost of living and the complexity of marital assets are statistically higher than the national average. In Miami, historical trends suggest that a seasoned family law attorney can command an hourly rate between $500 and $900. On the surface, this looks like an extraordinary income. However, the statistical analysis of Mark's overhead reveals a different story. To maintain a presence in the Brickell Financial District, Mark pays a premium for office space that signals stability and success to high-net-worth clients. In 2026, commercial real estate for boutique law firms in prime Miami locations has seen a steady climb. But the real drain on his revenue is not just the rent. It is the customer acquisition cost. Imagine if Mark relies on digital advertising to find new clients. In a saturated market like Florida, the cost per click for keywords like divorce lawyer near me or best family law firm can exceed $100 per single click. Statistically, it may take 20 clicks to generate one qualified lead and 5 leads to secure one signed retainer. This means before Mark has even opened a file, he may have spent several $1,000s in marketing equity just to get the client through the door. This is a potential outcome that many law students overlook when they see the high hourly rates. When you factor in the 2026 rates for malpractice insurance, which have adjusted for the increased litigiousness of the post-pandemic era, Mark's actual profit margin might hover around 35 to 40%. Now let us contrast Mark's situation with Sarah, a divorce lawyer practicing in a rural county in Ohio. Sarah's hourly rate is significantly lower, perhaps $200 to $300. However, her overhead is a fraction of Mark's. Her office is in a converted Victorian home that she owns outright. Her marketing is largely referral-based, driven by 20 years of community involvement, making her customer acquisition cost nearly zero. Statistically, Sarah may actually take home more net profit at the end of the year than Mark, despite charging half the price. This discrepancy highlights a critical data point. The divorce lawyer occupation is not just about legal expertise. It is a business of managing margins in highly localized economies. In 2026, we must also account for the technological shift in overhead. Historical trends show that prior to 2020, law firms spent heavily on massive physical libraries and rows of paralegals. Today, a significant portion of a firm's budget goes toward AI-driven legal research tools and automated document assembly. For a firm in 2026, the subscription cost for these platforms can range from $500 to $2,000 per month per user. While these tools increase efficiency, they also raise the baseline for the cost of doing business. If a lawyer is not using these tools, they are statistically more likely to fall behind in billable efficiency, but if they are using them, they must maintain a higher volume of cases to cover the subscription costs. Let us dive deeper into the actual labor of a billable hour. Many viewers might assume that if a lawyer bills 10 hours in a day, they have earned 10 hours of pay. In reality, the collection rate is a vital statistic that dictates the survival of a firm. Historical trends in family law show an average collection rate of about 85%. This means for every $10,000 Mark or Sarah bills, they might only see $8,500 of that money actually hit their bank account. Why? Because divorce is an emotionally charged and financially draining process for the client. As a case nears its conclusion and the initial retainer is exhausted, many clients struggle to pay the final bills, leading to what lawyers call the trailing receivable problem. Case studies of successful firms in 2026 show a pivot toward evergreen retainers, where the client must replenish their account once it hits a certain floor. This shift is a direct response to the statistical reality that family law has one of the highest rates of fee disputes of any legal specialty. To manage this risk, firms now employ dedicated billing coordinators. In a mid-sized firm, the salary for this position adds another $50,000 to $70,000 to the annual overhead, further squeezing the profit per partner. Furthermore, we must analyze the impact of the 2026 housing market on divorce litigation. Historically, the primary residence is the largest asset in a divorce. With interest rates and property values reaching new plateaus, the math of buying out a spouse has become nearly impossible for many middle-class families. This has led to a statistical rise in what lawyers call nesting arrangements or delayed sales. For the divorce lawyer, this means more complex drafting, more mediation sessions, and more billable hours spent on creative financing solutions rather than simple asset division. A single case that would have taken 20 hours to settle in 2016 might now take 40 hours of negotiation simply because the math of the 2026 economy is more restrictive. Consider the role of the paralegal in this economic structure. A high-performing family law paralegal is the engine of the firm. In 2026, the demand for experienced paralegals has driven their salaries to record highs, often reaching $80,000 to $100,000 in metropolitan areas. A lawyer who tries to save money by not hiring a paralegal often finds themselves performing administrative tasks that they cannot bill at their full attorney rate. This creates a ceiling on their income potential. The data shows that the most profitable lawyers are those who effectively leverage a team, billing their paralegals at a lower rate, perhaps $150 an hour, which still covers the paralegal's salary and contributes to the firm's net profit. But there is a psychological threshold to this pricing. As rates climb, the percentage of the population that can afford a private divorce lawyer is shrinking. This has given rise to a massive unbundled legal services market. In 2026, more people are filing pro se, meaning they represent themselves, and only hire a lawyer for a few hours of advice or a single document review. This trend is a double-edged sword for the occupation. While it reduces the lawyer's total revenue per client, it also reduces their liability and the emotional burden of the case. Statistically, the firms that have adapted to offer these limited scope representations are seeing a higher volume of clients, offsetting the lower per case profit. This leads us to a crucial question about the sustainability of the profession. The middle class is being priced out, and the wealthy are increasingly using prenuptial agreements to streamline the process. Where does that leave the average practitioner? The data suggests a polarization of the field. High-end luxury firms on one side and high-volume, tech-enabled commodity firms on the other. The boutique mid-market firm is facing a statistical squeeze that is forcing many to consolidate or specialize in niche areas like international custody or high-stakes business valuation. As we look at these numbers, it becomes clear that the divorce lawyer is not just a participant in the legal system, but a navigator of a complex financial landscape. Every decision, from the location of the office to the choice of legal software, is a calculated move to protect a thinning profit margin in a high-risk environment. But what happens when the legal system itself changes? What happens when technology doesn't just assist the lawyer, but starts to replace the core functions of the job? The math of the billable hour is under threat, and the ways lawyers are fighting back will surprise you. In the next part of this masterclass, we are going to look at the secret mathematics of the billable hour and the controversial practice of value-based pricing. We will also uncover the statistics behind why some lawyers are moving away from hourly billing entirely to protect their sanity and their bottom line. How do you charge for the emotional labor of a 3-hour phone call with a distraught client? The answer lies in a data-driven approach to human psychology that most people never see. The foundation of the divorce lawyer's economic existence is built upon a unit of time so small it governs every breath they take in the office: the 6-minute increment. In the legal world, this is known as 0.1 of an hour. When a lawyer looks at their watch, they are not seeing minutes, they are seeing tenths. This granular measurement creates a psychological and statistical environment that dictates everything from the speed of a phone call to the depth of a research memo. If a lawyer with an hourly rate of $500 spends 3 minutes reading a text message from a client and another 3 minutes responding, they have just generated $50 in revenue. If they do this 10 times a day, that is $500. But this is where the mathematics of the billable hour becomes a trap for the practitioner. Imagine if a lawyer named David is practicing in Chicago in 2026. David is a high-level litigator. His day is a relentless series of context-switching events. Statistically, the average family law attorney switches tasks every 8 to 12 minutes. Each time David switches from drafting a motion for temporary support to answering an emergency call about a parenting time dispute, there is a phenomenon called cognitive switching cost. While David might bill for the call, the time it takes for his brain to re-engage with the complex financial spreadsheet he was working on is often unbillable. Historical trends in law firm management suggest that for every 8 hours David spends at his desk, he is lucky to capture 6.5 billable hours. This 20% gap is known as billable leakage, and in the 2026 economy, it is the difference between a firm that is thriving and one that is facing insolvency. To combat this, many firms in 2026 have moved toward a controversial model called value-based pricing or alternative fee arrangements. In this scenario, instead of billing by the 10th of an hour, David might charge a flat fee of $15,000 for a specific phase of the divorce, such as the discovery process or the mediation phase. The statistical benefit for David is clear. If he uses AI-driven document review tools to complete 20 hours of work in 5 hours, his effective hourly rate skyrockets. However, the potential outcome for the client is a predictable cost. The tension arises when the case becomes high conflict. If David has agreed to a flat fee and the opposing counsel decides to file 15 frivolous motions, David's profit margin is decimated. He is now working for what effectively becomes $50 an hour while his overhead remains at $300 an hour. This brings us to the quantification of emotional labor. A 3-hour phone call with a distraught client is a common occurrence in family law. From a statistical perspective, these calls are often the least productive part of the case but the most demanding for the lawyer. In 2026, data-driven firms have started to implement what is colloquially known as the high-maintenance surcharge, though it is officially labeled as a complexity adjustment. Case studies show that clients who require daily emotional check-ins are statistically 40% more likely to dispute their final bill. To manage this, David's firm might require a larger initial retainer, perhaps $25,000 instead of $10,000, based on a preliminary psychological assessment of the case's conflict level. Let us break down the rule of thirds, which has historically governed the economics of the law firm. Under this rule, 1/3 of a lawyer's billable revenue goes toward their salary, 1/3 goes toward firm overhead, rent, staff, technology, and the final third is the firm's profit. In 2026, this model is under extreme pressure. With the rise of remote work, rent costs have fluctuated, but the cost of cybersecurity and high-end legal tech has filled that gap. If David generates $600,000 in billable revenue, he might expect to take home $200,000. But if his collection rate drops from 90% to 80%, That $60,000 loss comes directly out of the profit third, not the overhead third. This makes the divorce lawyer's income highly sensitive to the economic health of their clients. Consider a 2026 case study involving a mid-market divorce in a suburb of Dallas. The couple has a combined income of $250,000 and a home with $400,000 in equity. The lawyers on both sides know that if this case goes to a full trial, the combined legal fees will likely consume $100,000 to $150,000 of that equity. Statistically, this is a net loss for the family unit. The lawyer's role in this scenario is to perform a cost-benefit analysis at every step. Step 1. The initial consultation, where the lawyer assesses the client's goals versus the mathematical reality of the assets. Step 2. The filing of the petition and the request for temporary orders. Step 3. The discovery phase, where every bank statement and credit card bill from the last 5 years is scrutinized. During discovery, the billable hours explode. In 2026, a lawyer might use a forensic software tool that costs $500 per license to scan thousands of PDF statements to find hidden accounts or dissipated assets. While the software saves time, the lawyer must still review the output. If David finds a $5,000 discrepancy but it takes him 10 billable hours to prove it, he has cost the client $5,000 to find $5,000. This is the zero-sum game of divorce litigation. The lawyer must constantly ask, is this billable hour adding more value to the client's bottom line than it is costing them? Historical trends show that in high-conflict cases, the answer is often no. Yet the litigation continues because of the emotional drive for vindication. This emotional drive is what fuels the occupation's most profitable, but most dangerous sector, the scorched earth strategy. In this scenario, one or both parties are willing to spend more on legal fees than the assets are worth simply to prevent the other party from receiving them. For the lawyer, this is a gold mine of billable hours, but it is also a reputational and ethical minefield. In 2026, bar associations have become increasingly strict about the duty to minimize litigation costs. A lawyer who encourages a scorched earth approach may find themselves facing a fee audit or a grievance. Statistically, however, the firms that specialize in these high-conflict cases remain the most financially successful because they attract the demographic of clients for whom money is secondary to victory. But what if the client runs out of money midway through? This is the point of greatest risk for the occupation. In 2026, the use of third-party litigation funding in divorce has seen a measurable uptick. This is where a finance company pays the lawyer's fees in exchange for a portion of the final settlement. While common in personal injury law, its application in divorce is complex due to ethical rules. In states where this is permitted, it changes the lawyer's dynamic from a service provider to a partner in a financial venture. The data suggests that cases funded this way tend to last 30% longer and involve more aggressive tactics because the immediate pressure of the billable hour is removed from the client. As we look at these layers of financial and psychological complexity, we begin to see that the divorce lawyer is essentially a high-stakes risk manager. They are managing the client's legal risk, the firm's financial risk, and their own professional risk. The mathematics of the 0.1 hour is just the surface. Beneath it lies a complex web of predictive analytics, overhead management, and emotional tax. But even with all this data, there is one factor that can disrupt every calculation a lawyer makes. It is the factor that turns a standard file into a career-defining nightmare or a financial windfall. In the next part, we are going to expose the hidden impact of the professional saboteur, the opposing counsel who uses procedural friction as a financial weapon. We will analyze the statistics of how a single aggressive attorney can increase the cost of a divorce by 400%, and how the best lawyers in the country use game theory to counter these tactics. You will see exactly how the legal chess match is played when the goal isn't just to win the case, but to bankrupt the opposition before they even get to the courthouse. To understand the professional saboteur, we must first look at the statistical anatomy of a legal motion. In the landscape of 2026 family law, a single motion to compel discovery or a request for temporary orders is not just a document. It is a financial instrument designed to extract capital. Historical trends show that a standard uncontested divorce might cost a couple between $5,000 and $10,000 in total legal fees. However, when an aggressive opposing counsel enters the frame, the potential outcomes shift dramatically. Case studies of high-conflict litigation in states like California and Texas indicate that the presence of a scorched earth attorney can increase the total cost of a divorce by 300 to 400%, often without changing the final distribution of assets by more than 5%. This is the definition of a negative-sum game. Imagine if a professional named Michael is going through a divorce in Seattle in 2026. Michael's attorney is focused on a data-driven settlement, but the opposing counsel, let us call him the aggressor, employs a strategy of procedural friction. The first tactic is the paper blizzard. In this scenario, the aggressor files 15 separate motions within the first 60 days of the case. Each motion, whether it is a request to bifurcate the proceedings or a challenge to the valuation of a specific retirement account, requires a formal response. Statistically, the labor required to respond to a motion is nearly equal to the labor required to file one. If the aggressor spends 4 hours drafting a motion at $450 per hour, Michael's lawyer must spend 4 hours researching and drafting a rebuttal. This single exchange costs the marital estate $3,600. When repeated 15 times, Michael has spent over $50,000 before he has even stepped foot into a mediation room. The goal of the professional saboteur is rarely to win on the merits of the law. Instead, it is a calculated application of game theory, known as the attrition model. In game theory, specifically the prisoner's dilemma, the optimal outcome occurs when both parties cooperate. In a divorce, cooperation means sharing documents freely and agreeing on valuations. However, if one party defects by becoming aggressive, the other party is forced to defect as well just to protect their interests. This leads to a Nash equilibrium where both parties spend their entire net worth on legal fees to avoid being steamrolled by the other. In 2026, the cost of this defection is higher than ever because of the complexity of digital assets. Consider the statistical impact of discovery abuse. Historical trends in the early 2000s involved boxes of paper documents. In 2026, discovery involves terabytes of data. The professional saboteur will demand a forensic download of Michael's entire digital life, including 10 years of cloud storage, encrypted messaging apps, and cryptocurrency transaction logs. The cost to Michael is twofold. First, he must pay for an e-discovery expert to curate the data, which in 2026 carries a specialized hourly rate often exceeding $300. Second, his lawyer must review every single document to check for attorney-client privilege. If there are 50,000 pages of data and a lawyer can review 100 pages per hour, the math becomes catastrophic. This is the weaponization of the billable hour. The aggressor knows that Michael's retainer is finite. By forcing Michael to spend $20,000 on document review, the aggressor is effectively moving Michael closer to the break point. The break point is a statistical threshold where a litigant can no longer afford their counsel and is forced to either represent themselves or accept a predatory settlement. In the 2026 legal market, the breakpoint for a middle-class family with $200,000 in total equity often occurs at the 6-month mark of active litigation. Case studies show that once a party passes their breakpoint, their likelihood of achieving a fair market value settlement drops by 60%. The professional saboteur monitors this closely. They look for signs of financial stress, such as delays in paying experts or requests to downsize the legal team, and they respond by increasing the intensity of the litigation. Another tactic in the saboteur's arsenal is the deposition marathon. Imagine if the aggressor schedules depositions for Michael, Michael's employer, Michael's parents, and even his accountant. In 2026, a full day of depositions can cost upward of $5,000 when you factor in the attorney's time, the court reporter's fees, and the videographer's costs. Statistically, 80% of the information gathered in these depositions is never used in court. Its primary function is friction. It creates a psychological and financial tax that is intended to wear down Michael's resolve. The aggressor is betting that Michael will eventually say, "I do not care about the house anymore, just make it stop." At that moment, the saboteur has won, not through legal excellence, but through superior financial stamina. To counter these tactics, the highest-performing divorce lawyers in the U.S. use a strategy called calibrated reciprocity. This is a game theory approach where the lawyer mirrors the opponent's behavior, but with a slight delay and a clear path back to cooperation. If the aggressor files a frivolous motion, Michael's lawyer might respond by filing a request for sanctions, which is a formal ask for the court to make the other side pay Michael's legal fees for that specific motion. While historical trends show that judges are often reluctant to grant sanctions, the mere act of filing for them changes the aggressor's risk-reward calculation. In 2026, data-driven lawyers use litigation analytics software to track the specific judge's history with sanctions. If the data shows that the judge has a 15% chance of granting fees, The lawyer can present this statistic to the client to decide if the defensive move is worth the investment. The financial weaponization of the court system also extends to the use of expert witnesses. A common strategy in 2026 is the battle of the experts. If Michael has a small business, the aggressor might hire a valuation expert who uses a highly aggressive methodology to overvalue the company. This forces Michael to hire his own rebuttal expert. Each expert requires a retainer, typically between $5,000 and $15,000. By the time the two experts finish their reports and sit for depositions, the couple has spent $40,000 arguing over a business that might only be worth $100,000. This is why the occupation of a divorce lawyer is as much about financial engineering as it is about the law. The statistical reality is that the aggressive lawyer often makes more money in the short term, but they face higher rates of professional burnout and more frequent bar complaints. However, in a $13 billion industry, there is always a segment of the market that demands this level of aggression. Clients who are driven by spite rather than logic will seek out these saboteurs, creating a self-sustaining cycle of high-cost litigation. For the observer, the takeaway is clear. The cost of a divorce is not determined by the complexity of the assets, but by the temperament of the least reasonable person in the room. But what if there was a way to bypass this entire system? As we move into the second half of this decade, a new force is emerging that threatens to dismantle the traditional billable hour model and render the professional saboteur obsolete. It is a technological shift that is currently being tested in high-volume jurisdictions across the country. In the next part, we are going to look at the rise of algorithmic mediation and the AI-driven judge. We will analyze the shocking data on how 2026 startups are using machine learning to predict court outcomes with 90% accuracy, and how this is forcing divorce lawyers to either evolve or face a total loss of their market share. The era of the human-led legal battle is reaching its statistical limit, and the replacement is already here. The replacement is not a robot sitting behind a mahogany desk. It is a sequence of code that has analyzed every divorce decree filed in the United States over the last 30 years. In 2026, the divorce lawyer occupation is facing its most significant statistical disruption since the invention of the Internet. To understand this, we must look at the rise of predictive analytics and algorithmic mediation. Imagine if a lawyer named Linda, practicing in Denver, can now plug the specifics of a case, years of marriage, tax returns, property valuations, and even the personality profiles of both spouses into a specialized legal AI. Historical trends from the early 2020s showed that human judges were often inconsistent, influenced by factors as trivial as the time of day they heard a case or how recently they had eaten lunch. By 2026, however, software like JurisPredict or CaseCrunch has shifted the potential outcomes by providing a statistical probability of a ruling with 90% accuracy. This technological leap changes the very definition of a billable hour. In the past, Linda might have spent 15 hours researching case law to determine how a judge might divide a complex stock option plan. In 2026, the software does this in 3 seconds. From a statistical perspective, this creates a massive efficiency gain. But it also creates an existential crisis for the traditional firm's revenue model. If a task that used to generate $7,500 in billable revenue now costs essentially zero in labor, the lawyer must pivot. Case studies of forward-thinking firms in 2026 show a transition toward the role of a data-driven strategist. Instead of selling time, Linda is now selling her ability to interpret the data and manage the human variables that the algorithm cannot yet fully grasp. Let us look at a 2026 case study involving a couple named Alex and Jordan. In a traditional 2016 model, Alex and Jordan would have spent 18 months and $80,000 on discovery and litigation. In 2026, they opt for an algorithmic mediation platform. This platform functions as a digital neutral third party. It uses a process called game theory optimization. Alex and Jordan both input their absolute priorities. One might care more about staying in the family home, while the other prioritizes a clean break from retirement accounts. The algorithm runs thousands of simulations to find the one outcome that maximizes the satisfaction of both parties, while staying strictly within the legal bounds of Colorado state law. The cost for this is a $1,500 flat fee. For the occupation of the divorce lawyer, this technology represents a total loss of the low-complexity market. Statistics show that in 2026, nearly 40% of uncontested or low-conflict divorces are now handled entirely by these automated systems, bypassing the need for a traditional lawyer entirely. However, this does not mean the profession is dying. It is polarizing. As the bottom end of the market is automated, the high end becomes more specialized and lucrative. The 2026 divorce lawyer for high net worth individuals is no longer just a lawyer. They are a prompt engineer and a psychological architect. They use AI to find the needle in the haystack of big data. Consider the task of finding hidden assets. In 2026, cryptocurrency, decentralized finance protocols, and fractional ownership in digital assets like NFTs or virtual real estate have made traditional auditing nearly impossible for a human. A divorce lawyer now employs specialized AI agents that crawl the blockchain and public records to identify patterns of dissipation. This is a potential outcome of the technological arms race. As one side uses AI to hide money, the lawyer uses more advanced AI to find it. Step by step, the 2026 legal process looks remarkably different. Step 1 is the data ingestion phase, where all financial accounts are linked via secure APIs to the law firm's analysis engine. Step 2 is the conflict mapping phase, where AI identifies the 3 or 4 specific issues, perhaps the valuation of a private equity stake or the custody schedule for a child with special needs, that cannot be solved by a standard algorithm. Step 3 is where the human lawyer earns their premium. The lawyer steps in to negotiate these high-variance items. Statistically, these human-led negotiations are where 90% of the value is now concentrated. The data shows that while AI can solve the math of a divorce, it cannot solve the resentment. A machine can tell you that a house is worth $1.2 million, but it cannot tell you why your client is willing to lose $100,000 just to keep their ex-spouse from ever stepping foot in the garden again. The shift in the occupation's labor statistics is also telling. In 2026, the ratio of lawyers to support staff in a modern firm has flipped. Historically, a firm might have 1 lawyer for every 2 paralegals. Today, a firm might have 1 lawyer and 1 highly skilled legal technologist who manages the AI stack. The paralegal role is being subsumed by automated document assembly. Historical trends indicate that document preparation was the bread and butter of the junior associate's life. With that gone, law firms are struggling with a training gap. How do you train a senior partner if the junior associate tasks no longer exist? This has led to the rise of virtual simulation training, where new lawyers in 2026 spend hundreds of hours in VR courtrooms, practicing their negotiation skills against AI-driven, opposing counsel that simulate various personality types, including the professional saboteur we discussed earlier. Furthermore, we must analyze the statistical impact of remote litigation. In 2026, over 70% of family law hearings in the United States are conducted via high-definition teleconferencing. This has drastically reduced the non-billable time lawyers used to spend commuting to courthouses and waiting in hallways. From a business perspective, this should increase profitability. However, the data suggests that it has also led to a downward pressure on hourly rates. Clients are increasingly unwilling to pay a premium for a lawyer's prestigious office location if they only ever see that lawyer on a screen. This has leveled the playing field between the downtown high-rise firm and the rural practitioner, leading to a nationalized market where a lawyer in Nebraska can statistically compete for a case in New York if they have a specialized niche and a lower overhead. But there is a new risk emerging in the 2026 data: algorithmic bias and the legal hallucination. Case studies from this year show that while AI is efficient, it can occasionally produce false citations or biased recommendations if the underlying training data is flawed. A divorce lawyer's primary duty in 2026 is becoming a filter for these errors. The malpractice insurance rates for lawyers who do not have a verified human-in-the-loop process have skyrocketed. Statistically, a firm that relies too heavily on unverified AI is 3 times more likely to face a disciplinary hearing. This ensures that the human element of the occupation remains mandatory, even as the volume of human labor decreases. As we look at the numbers, we see a profession in the middle of a grand reorganization. The divorce lawyer of 2026 is a navigator of systems. They are managing a $13 billion industry that is being squeezed by efficiency on one side and increased asset complexity on the other. But what happens when the assets themselves become the primary obstacle? What happens when we move beyond houses and bank accounts into the world of intellectual property, future earning potential from digital personas, and the complex tax implications of a globalized workforce? The math of the divorce is getting harder, even if the tools are getting better. In the next part of this masterclass, we are going to dive into the most complex financial aspect of the occupation, the forensic deep dive. We will analyze the statistics of the 2026 tax code changes and how the modern divorce lawyer hunts for value in places you didn't even know existed. We are going to look at the secret world of offshore trusts, the valuation of personal brands, and the shocking data on how the wealthiest 5% of Americans use divorce as a strategic financial rebalancing tool. You will see why the smartest lawyers in the country are often the ones who never set foot in a courtroom. To understand the forensic deep dive of 2026, you must first understand that the modern marital estate has evolved into a multi-layered digital and physical labyrinth. The divorce lawyer in this high-stakes environment is less of a litigator and more of a financial detective, tasked with identifying value in places that simply did not exist a decade ago. We are no longer just looking at bank statements and brokerage accounts. In the current year, the statistical probability that a high-net-worth divorce involves at least one non-traditional asset, such as private equity carries, specialized digital intellectual property, or tokenized real estate, is nearing 85%. This has fundamentally shifted the labor distribution within the occupation. A lawyer in 2026 might spend 60% of their billable hours managing a team of forensic accountants, cyber investigators, and valuation experts, rather than writing legal briefs. Consider the case study of a character named Marcus, a software architect in Austin, Texas, who is navigating a divorce in 2026. Marcus does not have a traditional pension. Instead, his primary asset is a series of smart contracts that pay out royalties every time a specific piece of AI-driven logistics code is licensed. To a standard lawyer, this might look like simple income, but to a 2026 masterclass-level divorce lawyer, this is a complex valuation puzzle. Historical trends show that in the early 2020s, these assets were often overlooked or undervalued. Today, the lawyer must calculate the net present value of those future royalties over the next 15 years, adjusted for the rapid rate of technological obsolescence. This requires a specific statistical model, the discounted cash flow analysis for digital intangibles. If the lawyer fails to account for the potential outcomes of a market shift in AI, they could either over-index the asset, leaving Marcus bankrupt, or under-index it, leaving his spouse with nothing. The cost of hiring an expert to run these simulations can range from $15,000 to $40,000, but the statistical risk of not doing so could cost the client millions. Furthermore, we must analyze the impact of the 2026 tax code changes on property division. One of the most critical shifts in the current landscape is the treatment of what we call the phantom asset. Imagine if Marcus and his spouse, Sarah, own a significant amount of a specialized cryptocurrency that has appreciated by 4,000%. If they divide this asset in 2026, the tax liability triggered by the transfer could be catastrophic. The modern divorce lawyer uses a strategy called tax basis balancing. Instead of a simple 50-50 split of the asset, the lawyer calculates the embedded tax liability of every single item on the marital balance sheet. Statistically, a $100,000 savings account is worth significantly more than $100,000 worth of highly appreciated stock. By factoring in the future capital gains tax, the lawyer creates a net neutral trade. This is where the smartest practitioners earn their keep, not by fighting in court, but by performing financial rebalancing that minimizes the amount of the estate lost to the federal government. Another burgeoning area in the 2026 statistical analysis of this occupation is the valuation of the personal brand or the digital persona. Let us look at a case study of a creator named Chloe. Chloe has spent the last 5 years building a massive following on decentralized social platforms. Her revenue comes from a mix of direct subscriptions, digital merchandise, and AI likeness licensing. In 2026, many U.S. jurisdictions have begun to recognize the enhanced earning capacity of a digital persona as a marital asset, similar to how a medical degree was viewed in the 1980s. The challenge for the divorce lawyer is to separate the personal goodwill of Chloe, which is not divisible, from the enterprise goodwill of her brand, which is. This requires a deep dive into Chloe's analytics. The lawyer will examine the conversion rates, the churn rate of her subscribers, and the historical trends of her sponsorship growth to build a statistical model of her future earning potential. If the lawyer can prove that a significant portion of the brand's success was due to the administrative or emotional support of the non-creative spouse, the potential outcome is a massive buyout or a long-term percentage of the brand's revenue. This brings us to the secret world of strategic rebalancing for the top 5%. For the ultra-wealthy in 2026, divorce is often seen not just as a personal failure, but as a tactical opportunity to reset a financial portfolio. We are seeing a rise in what sociologists call the collaborative exit. In these scenarios, the divorce lawyer acts as a project manager for a massive corporate restructuring. Instead of a battle, The process is a series of choreographed transfers into specialized trusts. Statistically, these cases have the lowest rate of courtroom appearances but the highest legal fees. Why? Because the complexity of the tax and trust law involved is so high that it requires hundreds of hours of senior partner time. A single mistake in the timing of a trust distribution during the divorce process could result in a gift tax penalty that exceeds the cost of the entire legal team. Let us also address the statistics of the hidden hunt. Despite the increased transparency of the 2026 financial system, the use of offshore shell companies and layered LLCs remains a factor. However, the methodology of the search has changed. Historical trends involve tracking physical money trails. Today, it is about data pattern recognition. A divorce lawyer in 2026 uses specialized software to look for anomalies in lifestyle spending versus reported income. If a client like Sarah claims she only earns $150,000 a year, but her social media data shows her traveling on private jets and staying in luxury villas, the lawyer has found a statistical discrepancy. By using a lifestyle audit, the lawyer can move the court to shift the burden of proof onto Sarah to explain where the funds are coming from. The cost of this forensic software is high, but the potential recovery of hidden assets often represents a 10-to-1 return on investment for the client. The final layer of the forensic deep dive is the calculation of human capital. In 2026, we are seeing more cases focused on the opportunity cost of the stay-at-home spouse. This is not just about alimony, it is about the statistical calculation of what that spouse would have earned had they not left the workforce. Lawyers now use labor market economists to project a 30-year career path, factoring in lost raises, lost retirement contributions, and the decreased value of a resume with a 10-year gap. This data-driven approach has replaced the old-fashioned gut feeling of a judge. Now, when a lawyer stands in front of a bench, they are presenting a spreadsheet backed by Bureau of Labor Statistics data and private sector wage growth indices. As we peel back these layers, it becomes clear that the divorce lawyer is the primary gatekeeper of the American middle and upper-class wealth transfer. Every year, billions of dollars are reallocated based on the formulas and strategies we have discussed. But there is a factor that even the most advanced forensic software cannot account for: the human variable of the child. When children are involved, the math of the divorce changes from a simple asset division to a complex, multi-decade financial and social projection. The cost of raising a child in 2026 has reached new heights, and the way lawyers calculate child support and custody time is being revolutionized by a new set of controversial algorithms. What happens when a machine tells a parent they are statistically less likely to provide a stable environment? What is the true cost of a 50-50 custody split in an era where parents live in different states due to remote work? In the next part, we are going to break down the cold, hard statistics of the custody battle. We will analyze the data on how custody arrangements impact the long-term health of both parents, and the shocking reality of how the billable hour is used as a weapon in the fight for time. You will see the numbers behind the most emotional part of the job, and how the legal system is trying and often failing to put a price on the parent-child bond. In the 2026 legal system, the parent-child bond is no longer treated as a purely sentimental connection in the eyes of the court. It has been translated into a series of statistical variables known as overnights. To the divorce lawyer, custody is often the most labor-intensive and unpredictable sector of their practice, primarily because it serves as the linchpin for the entire financial structure of the post-divorce family. In the United States, the calculation of child support is largely driven by the income shares model, which is currently used in over 40 states. Under this model, the court estimates the total amount of money parents would spend on their children if they remain together, and then divides that obligation based on their respective incomes and the percentage of time each parent spends with the child. This creates a high-stakes environment where a shift of just 5% in custodial time can result in a potential outcome of tens of thousands of dollars in shifted support obligations over the course of a decade. Imagine a case study involving a father named Jason in Atlanta, Georgia. In 2026, Jason is a mid-level manager at a logistics firm, and his spouse, Maria, is a freelance graphic designer. In their jurisdiction, the 2026 child support guidelines have been adjusted to account for the massive inflation seen in the early 2020s, specifically regarding childcare and healthcare premiums. If Jason has the children for 140 overnights per year, his support obligation might be $1,200 per month. However, if he can secure 182.5 overnights, the statistical definition of a true 50-50 split, his obligation could drop to nearly zero if their incomes are relatively equal. For the divorce lawyer, this 42-day discrepancy represents the difference between a routine settlement and a high-conflict litigation cycle. Historical trends show that when the financial stakes of custody are this high, the billable hours dedicated to proving one parent's superior fitness or the other's deficiencies skyrocket. In 2026, the cost of litigating a custody dispute has reached a statistical peak. Step 1 for any lawyer in a high-conflict custody case is the appointment of a guardian ad litem or a custody evaluator. These are neutral third-party professionals, often other lawyers or PhD-level psychologists, who are tasked with investigating the family dynamic. In major metropolitan areas, the initial retainer for a guardian ad litem in 2026 typically starts at $5,000, with the final bill often exceeding $15,000. This cost is usually split between the parents, but the tactical use of these experts is where the divorce lawyer's expertise is tested. A lawyer must prepare their client for hours of interviews, psychological testing, and home visits. From a data perspective, the recommendation of the guardian ad litem is followed by the judge in over 85% of cases. Therefore, the billable hours spent influencing the evaluator's perception are statistically the most valuable hours in the entire case. Furthermore, we must analyze the 2026 phenomenon of the remote work move away. As more U.S. companies have solidified permanent remote work policies, the geographical constraints on divorced parents have loosened, leading to a surge in interstate custody disputes. Let us look at the potential outcomes for a mother named Emma, who wants to move her children from Chicago to Florida to be closer to her extended family while keeping her tech job. Under the Uniform Child Custody Jurisdiction and Enforcement Act, or UCCJA, the legal hurdles for such a move are immense. Emma's lawyer must build a case based on a multi-factor statistical analysis: the quality of schools in the new location, the delta in the cost of living, and the impact on the non-custodial parent's visitation schedule. In 2026, lawyers are increasingly using specialized travel cost algorithms to propose long-distance parenting plans that account for the rising cost of airline tickets and the logistics of unaccompanied minors. The billable time required to negotiate a 25-page interstate parenting plan is 3 to 4 times higher than a standard local plan. The weaponization of the billable hour in custody cases often manifests in the battle over extraordinary expenses. In 2026, the definition of what is extraordinary has expanded to include high-end tutoring for AI-driven curricula, competitive youth sports fees which have tripled in the last 5 years, and the cost of digital devices and data plans. Lawyers now spend an average of 15 to 20% of their mediation time just debating the pro rata split of these costs. Statistically, these debates are often economically irrational. Parents might spend $5,000 in legal fees to decide who pays for a $2,000 club soccer fee. However, for the divorce lawyer, these disputes are mandatory because they set the precedent for the next 10 to 15 years of the child's life. Another critical data point in the 2026 custody landscape is the rise of the parenting coordinator. This is a quasi-judicial role designed to reduce the burden on the court system. A parenting coordinator has the authority to make binding decisions on small disputes, like whether a child can go to a sleepover during the other parent's time, without the parents having to file a formal motion. While this is intended to save money, historical trends indicate that for high-conflict couples, the parenting coordinator becomes another billable venue. In 2026, a parenting coordinator's hourly rate often mirrors that of a senior attorney, ranging from $300 to $500. For the divorce lawyer, managing the relationship with the coordinator is a new form of administrative litigation that requires constant documentation and rapid response communication. The statistical reality of the 2026 custody battle is that it is becoming increasingly automated, yet the human cost is higher than ever. Algorithms now provide judges with standardized parenting schedules based on the child's age and the parent's work-life balance data. These templates are designed to provide a predictable baseline, but they also create a trap for the unprepared lawyer. If a lawyer cannot provide specific, data-backed reasons why a standard 2-2-3 schedule is detrimental to their client's situation, the judge is statistically likely to default to the algorithm. This has forced lawyers to become experts in child development data, often citing longitudinal studies on the impact of shared parenting on child well-being to justify their positions. Behind the scenes, the divorce lawyer is also managing the psychological tax of these cases. Case studies show that custody litigation is the primary driver of attorney burnout and secondary traumatic stress. In 2026, firms are beginning to factor this into their pricing models. Some boutique firms have implemented a custody surcharge or a high-intensity file fee to account for the fact that these cases require more emotional management, more emergency weekend phone calls, and more frequent interactions with the court's social services department. The data suggests that a lawyer who carries more than 10 active custody trials at once is 50% more likely to suffer from significant professional impairment within 24 months. As we conclude this part of the analysis, we see that the custody battle is not just a fight for time. It is a fight for the financial and social blueprint of the future. The divorce lawyer is the navigator of this system, translating raw human emotion into the cold language of percentages and pro rata shares. But as the case moves from the nursery to the boardroom, a new set of challenges emerges. What happens when the assets are not just bank accounts, but complex business entities and intellectual property? How does a lawyer value a company that only exists on a server? The next part of our masterclass will take us into the deep, often dark world of the high-stakes business valuation. We will examine the statistics of the 2026 corporate divorce crossover, where a single subpoena can threaten a $100 million IPO. We will look at the data on how lawyers use forensic auditors to dismantle a spouse's business empire, and the shocking tactics used to shield corporate assets from a marital split. The chess match is about to get significantly more expensive, and the players are operating at a level of financial complexity that most people will never experience. In the high-stakes arena of 2026, the intersection of corporate law and family law has created a specialized niche within the divorce lawyer occupation that operates more like a mergers and acquisitions firm than a traditional legal practice. When a business is the primary asset in a marital estate, the statistical complexity of the case increases by an order of magnitude. Historical trends show that in cases involving a closely held corporation or a high-growth startup, the legal fees alone can consume between 5 and 10% of the total business valuation. This is because the divorce lawyer must now act as a forensic economist, navigating the dense fog of cap tables, shareholder agreements, and deferred compensation structures. To the 2026 practitioner, a business is not just a source of income. It is a living entity whose value can be manipulated, shielded, or dismantled depending on the legal strategy employed. Imagine a character named Robert, a founder of a Series C biotechnology startup in Boston. In 2026, Robert's company is valued at $250 million on paper, but it has not yet reached a liquidity event like an IPO or acquisition. His spouse, Catherine, is represented by a lawyer who specializes in high-stakes business valuation. The first statistical hurdle the lawyer faces is the determination of the valuation date. In a volatile 2026 economy, the difference between valuing a company in January versus June could mean a delta of $50 million. The lawyer must decide whether to push for a date of separation valuation or a date of trial valuation. Historical trends in Massachusetts and similar jurisdictions indicate that the court has broad discretion here, making the lawyer's ability to argue for a specific timeline a multi-million-dollar skill set. The deep dive into business valuation usually begins with the selection of a methodology. There are 3 primary statistical approaches: the asset-based approach, the market approach, and the income approach. For a startup like Robert's, the asset-based approach is often useless because the primary value lies in intellectual property and future growth potential, rather than physical machinery or real estate. The market approach, which looks at comparable companies that have recently sold, is also difficult in 2026 due to the unique nature of AI-integrated biotech firms. This leaves the income approach, specifically the discounted cash flow or DCF model. The divorce lawyer hires a forensic valuation expert to project Robert's company's earnings over the next 10 years, and then discounts them back to their present value using a specific risk rate. This risk rate is the most contested statistic in the room. A lawyer representing the business owner will argue for a high risk rate, perhaps 18%, to lower the present value. The lawyer representing the non-owning spouse will argue for a low risk rate, maybe 10%, to inflate the value. This discrepancy is where the billable hours explode. Step by step, the lawyer's team will issue a series of comprehensive subpoenas known in 2026 as a data dump request. They aren't just looking for tax returns. They are demanding access to the company's internal Slack logs, Jira project management boards, and real-time financial dashboards. Why? Because historical trends show that business owners often begin to artificially suppress their company's growth or increase their personal expenses when they anticipate a divorce. This is known as the lifestyle burn. If the lawyer finds a statistical anomaly where the company's travel and entertainment budget doubled in the same month the divorce was filed, they have found a potential outcome of significant dissipation. The lawyer will use this data to argue for an add-back, where the court treats that wasted money as if it still exists in the marital pot. Furthermore, we must analyze the Pereira versus Van Camp models, which are the two primary statistical frameworks used in community property states like California to divide business interests. A 2026 divorce lawyer must be a master of these two formulas. The Pereira method is used when the business's growth is primarily due to the personal efforts and skills of the spouse. In this model, the court calculates a reasonable return on the original separate property investment and allocates the rest of the increase in value to the community. The Van Camp method is used when the growth is due to the nature of the business itself or market factors. Here, the court determines the reasonable value of the spouse's services and allocates any excess profit to the separate property. In Robert's biotech case, the lawyer's choice of model is a tactical chess move. If the lawyer can prove Robert is a once-in-a-generation genius whose personal brand drives the company, they use Pereira to maximize the spouse's share. If they argue Robert is just a lucky passenger on a market trend, they use Van Camp to protect Robert's equity. Another major challenge in 2026 is the issue of double-dipping. This is a statistical controversy where a lawyer tries to value a business based on its future income for property division, and then uses that same future income to calculate alimony. Many U.S. jurisdictions have historical trends that prohibit this, but the math is rarely clean. A savvy lawyer must perform a carve-out, separating the income stream used for valuation from the income available for support. If this is not done correctly, the potential outcome is a financial obligation that exceeds the business owner's actual cash flow, leading to a forced sale of the company. In 2026, we are seeing a rise in specialized insurance products designed to hedge against these valuation errors, but the premiums are astronomical. The impact on corporate governance is perhaps the most overlooked statistical reality of the divorce lawyer occupation. When a spouse claims a 50% interest in a founder's stock, they aren't just asking for money. They are potentially asking for voting rights. Imagine if Catherine, in our case study, were to be awarded a significant portion of Robert's voting shares. This could trigger a change of control clause in the company's venture capital contracts, potentially defaulting on millions in debt or preventing an IPO. The divorce lawyer must navigate these shareholder agreements, which often contain buy-sell provisions that force the spouse to sell their interest back to the company at a predetermined, often lower, price. The litigation then shifts to whether these agreements are unconscionable or binding. Statistically, the cost of a corporate lawyer to consult on these specific clauses adds another 200 to 400 hours of billable time to the case. Case studies from 2026 show that the most successful divorce lawyers in this tier are those who understand the liquidity trap. A court might award Catherine $20 million as her share of the biotech company, but Robert doesn't have $20 million in cash. He has it in paper equity. This leads to the negotiation of the equalization payment. The lawyer must draft a long-term promissory note, often secured by the stock itself, with an interest rate that reflects the 2026 market. If the interest rate is too high, Robert's business fails. If it is too low, Catherine is losing money to inflation. The drafting of these structured settlements is a high-wire act of financial engineering that takes months to finalize. As the financial complexity reaches its zenith, the divorce lawyer is also managing the reputation risk of the company. In 2026, a messy public divorce for a CEO can cause a company's valuation to plummet, hurting both parties. This leads to the statistical rise of the private judge and the confidential arbitration process. By paying a premium, often $1,000 an hour, to a retired judge, the parties keep their financial data off the public record. For the divorce lawyer, this environment is even more intense, as the rules of evidence are more flexible and the pace is much faster. The business valuation part of the masterclass reveals a cold reality. At the highest levels of the occupation, a divorce is a corporate liquidation. The lawyer is the liquidator, and the statistics of the 2026 economy are the primary weapons. But even after the business is valued and the assets are divided, there is one final unavoidable tax that every lawyer must account for. It is the cost of the endgame, the final settlement or the trial that puts a definitive period at the end of the sentence. In the next part, we are going to look at the statistical anatomy of the trial. We will analyze the data on why only 5% of cases go to court, but why those 5% represent 50% of all legal fees. We will look at the cost of expert testimony, the psychology of the witness stand, and the shocking data on how 2026 juries, in the few states that still allow them for certain issues, are increasingly volatile. The preparation for the final battle is where the true elite are separated from the average practitioners, and the numbers behind a trial day will leave you breathless. To understand the trial, you must understand the math of the outlier. In the United States in 2026, there is a pervasive statistical anomaly in the divorce lawyer occupation. While approximately 95% of cases reach a settlement before the gavel ever falls, the remaining 5% of cases account for nearly 50% of a firm's annual billable revenue and 90% of its professional stress. This is the phenomenon of the trial iceberg. What the public sees is the few days of dramatic testimony, but beneath the surface lies a massive, frozen block of preparation hours that can sink a client's financial ship if not navigated with surgical precision. For the elite divorce lawyer, the trial is not a failure of mediation. It is the ultimate data validation exercise where every piece of evidence, every expert report, and every financial disclosure is stress-tested in a public forum. Imagine a case study involving a character named James, a high-earning medical consultant in Chicago. James is entering a scheduled 3-day trial in June 2026. To the uninitiated, 3 days of court at an hourly rate of $600 seems like an 18-hour billable event totaling $10,800. The statistical reality is far more punishing. Historical trends suggest a prep-to-performance ratio of 5-to-1. For every 1 hour James's lawyer spends in front of the judge, their team has spent 5 hours in trial preparation. This includes drafting a comprehensive trial brief, prepping witnesses, organizing digital exhibit folders, and performing dry-run cross-examinations. By the time James walks into the courtroom on Tuesday morning, his legal team has already billed 90 to 100 hours of prep time. In 2026, the potential outcome for a 3-day trial is often a pre-trial bill exceeding $60,000 before the first witness is even sworn in. The 2026 courtroom itself has become a high-tech environment that adds new layers to the billable structure. We are seeing a widespread shift toward digital evidence management systems where every bank statement, text message, and forensic report is indexed with metadata for instant retrieval. While this increases efficiency, the labor required to upload, tag, and verify thousands of pages of digital discovery is a significant statistical driver of paralegal hours. In James's case, his lawyer utilizes a trial technician, a specialized professional who manages the multi-screen display of evidence for the judge. In 2026, these technicians command a daily rate of $1,500 to $2,500. If the trial lasts 3 days, the tech support alone costs more than a month's mortgage payment for most American families. This is the hidden burn rate of modern litigation. Now let us analyze the daily burn rate of a trial in progress. A trial day in 2026 typically starts at 9 a.m. and ends at 4:30 p.m. But for the lawyer, the day begins at 5 a.m. and ends at midnight. The hours spent in court are just the midpoint. Before court, the lawyer reviews the day's planned testimony. After court, they must review the transcript of the day's events to prepare for the next day's rebuttals. In 2026, court reporters utilize AI-assisted real-time transcription, allowing lawyers to receive a digital feed of everything said in the courtroom with only a few seconds of delay. This technology, while revolutionary, comes with a premium daily fee. Statistically, the cost of daily transcripts can range from $800 to $1,200 per day. For a lawyer, the ability to search a transcript for a specific contradiction while a witness is still on the stand is a powerful tool, but it is one that only the wealthiest litigants can afford to deploy. The expert witness waiting fee is another statistical trap that defines the occupation's financial landscape. Imagine if James has hired a forensic accountant to testify about his spouse's alleged dissipation of marital assets. In 2026, a top-tier forensic accountant charges $500 per hour. Because court schedules are notoriously unpredictable, often delayed by earlier hearings or administrative issues, that expert might sit in the hallway for 6 hours before being called to the stand. This is known as the standby tax. The expert is billing for every minute they are away from their office. Historical trends show that in complex divorces, expert witness fees can equal or even exceed the primary attorney's fees. In a 3-day trial, it is common to see $20,000 to $30,000 spent just on the logistics of expert testimony. Furthermore, we must address the statistical wild card of the 2026 judge. While the law provides the framework, the final ruling is subject to judicial discretion, which is a variable that no algorithm can perfectly predict. In 2026, lawyers use litigation analytics to track a judge's past rulings on specific issues, such as the duration of alimony or the division of unvested stock options. However, even with a 90% confidence interval, the human element remains. A judge may be having a bad week, or they may be particularly sensitive to a specific type of testimony. This uncertainty is why the lawyer's primary job in a trial is risk mitigation. Step by step, the lawyer builds a record for appeal. They are not just arguing to win the trial. They are arguing to ensure that if the judge makes a legal error, James has the statistical grounds to overturn the decision in a higher court. The billable hours spent on preserving the record for appeal are an insurance policy for the client's assets. The psychological tax of the trial day is also a measurable data point. In 2026, studies on the divorce lawyer occupation indicate that the cognitive load during a trial is equivalent to that of an air traffic controller during a storm. The lawyer must manage the judge's temperament, the client's emotional outbursts, the opposing counsel's tactical objections, and the complex flow of financial data simultaneously. This high-pressure environment leads to a phenomenon called decision fatigue. Statistically, the quality of legal arguments can degrade as the trial day progresses, which is why elite lawyers often structure their most critical witnesses for the morning session. This tactical use of human psychology is what separates the top 5% of the profession from the rest. But the end of the trial is not the end of the math. Once the judge issues a ruling, the lawyer enters the post-trial phase. This involves the drafting of the final judgment of dissolution, a document that can run 50 to 100 pages in 2026 due to the complexity of modern asset division. Every word in this document must be negotiated to ensure it aligns with the judge's verbal ruling. If there is a dispute over the wording of a single paragraph regarding the transfer of a 401k, it can trigger another series of motions and hearings. Historical trends indicate that the period between the trial's end and the final entry of the decree can take 3 to 6 months and add another 20% to the total legal bill. As we look at the numbers, the trial emerges as a high-stakes financial engine that produces the definitive data points for a family's future. The divorce lawyer is the engineer of this engine, and their billable hour is the fuel. But as we move toward the conclusion of this masterclass, we have to look beyond the individual case and toward the macro statistics of the profession itself. What is the long-term outlook for the people who do this work? What are the potential outcomes for the American legal system as the cost of this expertise moves further out of reach for the average person? We have analyzed the billable hour, the forensic deep dive, the custody battle, and the trial. Now it is time to look at the ultimate scorecard. In the final part of this series, we are going to look at the professional endgame. We will analyze the data on attorney longevity, the rise of legal deserts where no divorce lawyers can be found, and the shocking statistics on the global consolidation of family law firms. We are also going to reveal the one number that determines whether a divorce lawyer is truly successful or just a high-priced casualty of an exhausted system. The final piece of the puzzle is about to fall into place, and it will change the way you look at the business of divorce forever. The ultimate scorecard for the divorce lawyer in 2026 is not found in a courtroom victory or a high-profile settlement. It is found in the survival statistics of the practitioner themselves. As we reach the conclusion of this masterclass, we must confront the reality of the professional endgame. Historical trends indicate that family law has one of the highest attrition rates in the entire legal industry. While corporate lawyers may struggle with the boredom of document review, the divorce lawyer struggles with the accumulation of human tragedy. Data from 2026 suggests that the average career span for a lawyer specializing exclusively in high-conflict family law is approximately 12 to 15 years before a significant career pivot or burnout occurs. This creates a perpetual talent vacuum that dictates the high cost of the service. To understand this, let us look at the case study of a lawyer named Thomas. In 2026, Thomas has reached his 15th year of practice in suburban Virginia. Statistically, 40% of the peers he graduated with have already left the field of family law. Some moved into estate planning, where the clients are usually deceased and therefore less argumentative, while others left the law entirely for roles in corporate compliance or mediation. Thomas represents the survivor category. However, his survival has a mathematical cost. In 2026, the cost of professional liability insurance for a lawyer with Thomas's caseload has increased by 25% over the last 5 years, reflecting the increased statistical likelihood of malpractice claims in high-emotion cases. For the occupation, the endgame is often a trade-off between high earning potential and psychological sustainability. This leads us to the growing phenomenon of the legal desert. In 2026, a statistical analysis of the United States reveals that over 1,300 counties are considered legal deserts, meaning they have fewer than one lawyer for every 1,000 residents. In the realm of divorce law, this crisis is even more acute. While metropolitan areas are saturated with practitioners, rural America is facing a total collapse of accessible family law services. Imagine a resident in a rural county in Nebraska who needs a divorce lawyer in 2026. They may have to travel 150 miles to find a lawyer who is not already representing their spouse. This geographic scarcity allows the few remaining rural lawyers to maintain high rates, but it also creates a massive backlog in the court system. Statistically, the time to finalize a divorce in a legal desert is 40% longer than in a metropolitan area, simply due to the lack of available counsel to move the paperwork. Furthermore, we must analyze the 2026 trend of corporate consolidation. Historical trends in the 1990s and 2000s saw the rise of the boutique family law firm. Today, however, we are seeing the Walmartization of the occupation. Private equity firms have begun to acquire successful local practices and consolidate them into national brands. These consolidated firms use centralized administrative hubs and AI-driven intake systems to maximize the efficiency of every billable hour. For the lawyer working within this system, the potential outcome is a more stable salary and better benefits, but at the cost of professional autonomy. The data shows that lawyers in these consolidated firms are expected to maintain a realization rate, the percentage of worked hours that are actually billed and collected, of at least 95%. In a profession where human emotion often disrupts the schedule, this statistical pressure is a primary driver of the high turnover rates we discussed earlier. This brings us to the one number that determines the true success of a divorce lawyer in the 2026 economy: the value-to-friction ratio. This is a metric used by top-tier firms to measure how much revenue a case generates relative to the amount of administrative and emotional friction it creates. A case with a high value-to-friction ratio is one where the assets are clear, the clients are rational, and the billable hours are paid promptly. A case with a low ratio involves constant fee disputes, emotional emergencies, and procedural sabotage from opposing counsel. In 2026, the most successful lawyers are those who have mastered the statistical art of case selection. They use predictive modeling during the initial consultation to identify and reject potential clients who fall into the low ratio category. This data-driven selectivity is why the top 5% of earners in the field can maintain seven-figure incomes while working fewer hours than their mid-tier counterparts. Let us consider the macroeconomic impact of this occupation on the U.S. legal system. In 2026, the cumulative revenue of the divorce law sector contributes approximately $13.5 billion to the GDP. However, the indirect costs are much higher. When you factor in the lost productivity of the litigants, the strain on the court system, and the secondary effects on the housing and credit markets, the business of divorce is a multi-hundred-billion-dollar economic force. The divorce lawyer is the navigator of this wealth transfer. Step by step, as assets move from a joint estate into separate portfolios, the lawyer's fees represent a transaction tax on the dissolution of the American family unit. Historical trends show that as the wealth gap in the U.S. widens, the divorce lawyer occupation becomes even more polarized. We are moving toward a future where the wealthy have access to elite financial engineers disguised as lawyers, while the middle class relies on automated platforms and unbundled services. The potential outcomes for the profession over the next decade are bifurcated. On one hand, technology will continue to commoditize the routine aspects of the job. By 2030, it is statistically probable that 80% of simple divorces will be handled by autonomous systems. On the other hand, the complexity of high-end marital estates, involving global cryptocurrency holdings, AI-generated intellectual property, and multinational trusts, will ensure that the demand for human expertise remains high at the top of the market. The divorce lawyer of the future will be less of a generalist and more of a specialized asset protection consultant. As we look at the final data points, we see a profession that is both essential and embattled. The divorce lawyer occupation is a mirror of the society it serves. It reflects our shifting values, our economic volatility, and our struggle to balance the cold logic of the law with the heat of human emotion. For the practitioner in 2026, success is not just about the numbers on a billing statement. It is about the ability to navigate a system that is increasingly defined by data, without losing the human intuition that allows them to see the person behind the file. The statistics tell us that the number of divorces may be declining, but the value of each case is increasing. The hours are longer, the technology is more complex, and the stakes have never been higher. We have decoded the billable hour, unmasked the professional saboteur, and analyzed the forensic hunt for hidden wealth. This has been a masterclass in the most misunderstood occupation in America. But while we have covered the business of the end of love, there is another side to the legal coin that is equally complex and even more secretive. The data suggests that the same strategies used to dismantle a marriage are now being used to protect wealth before a marriage even begins. The rise of the predatory prenuptial agreement is the next great statistical frontier in the U.S. legal market. How do the wealthiest 1% use the law to create bulletproof financial barriers? And what happens when those barriers are tested by a new generation of lawyers armed with the same AI tools we have discussed today? The battle for the future of American wealth is not just happening in the divorce courts. It is happening in the drafting rooms years before the wedding. In our next deep dive series, we will expose the hidden mathematics of the prenuptial industrial complex and show you why the most important contract you will ever sign is the one that assumes everything will fail. Stay tuned for the next masterclass.